All right. The recording has just started on this motion to compel and motion for summary judgment. You may proceed. Plaintiffs.
Your Honor, we move to compel the production of all recorded statements and all incident reports in this case. Now, we recognize that the defendants have produced a declaration from, I believe it was an adjuster of the insurance company on the case, saying that there was no recorded statement made, and there are no witness statements, nothing of that kind in this case. And while we can accept that, we would like an order from the court that compels them to turn over the any witness statements in the case, simply because there's been a slow trickle of evidence in this case that's being produced. We just received 3 days ago an incident report that was created and written by one of the defendants on the day of the accident nearly 3 years ago. And we've been requesting that for, since the beginning of this case. We didn't even know it existed. We were requesting all witness statements, anything of this nature, which is an incident report, and it was just now provided 3 days ago. We found out that it existed in the deposition of the defendant, Jacob Allen Johnson, where he revealed that he had created an incident report. We then requested that it be produced. It was not, so we moved to compel it. It was finally produced, but that is only one incident report. There was another employee that was actually there at the scene, which also had not been revealed to us until the deposition, which was on March 10th, just a little over a month ago. We would like to find out if there is a incident report that was filled out by that other employee, or if there's anything else. It just hasn't. The normal tools of discovery have not proven sufficient to obtain discovery in this case. So we would like orders from this court so that that carry with it the weight of contempt for noncompliance for both all the, any incident reports in this case and any witness statements in this case.
Response.
Yes, Your Honor. We did produce the incident report and the declaration. Just by way of background, our firm took over this case from prior counsel to handle the case for the case that was non-suited. It had been going on, I'm not quite certain how long, but we took over the case in November of just last year, so we've only had it for a couple of months. I understood when I took over the case and started working on this case that everything from the client, defendant, and the driver had been turned over. I wasn't, I guess, perhaps wrongly, that the due diligence had been done. I would assume going into the deposition of the driver, Mr. Jacob Johnson, that everything that we had been turned over. When I became aware that there might be additional information in the deposition as well, we worked to get that information. I've been on the phone quite a few times just to make sure and ensure that nothing exists other than what we turned over. The incident report was just a few days ago, and that's when I got it. This is not a delay tactic. Counsel asked for a declaration that there were no recorded statements. Mr. Johnson in his deposition did state that he thought that his statement was being recorded by the insurance company. I followed up on that. I did not think it had been, but I did follow up, made inquiries. Both the property damage and the bodily injury adjusters were contacted, interviewed, discussed, and there were no recorded statements. And plaintiff's counsel told me that if we produced a declaration, this would be a moot issue in front of the court. We did produce that declaration. We actually filed it as soon as I got it. It was not an affidavit, as the adjuster is with the COVID-19 issue, and her pending pregnancy did not want to appear before someone else to get a notary to get it done. but I did, reading in their reply brief that was filed, I believe, yesterday, regarding an incident report regarding Gansey McClurdy, which was a witness to the case. I followed up again with the client. There is no such incident report. The only incident report in this case was filed by, or was filled out by Jacob Johnson, the driver. They have everything we have, Your Honor, and a declaration saying there's nothing else that exists. I don't think an order is necessary. We're on the record here. Basically they have everything that we have, or that I'm aware of, and after, quite a bit of diligence have been able to get.
Mr. Harper, I understand that. Just in an abundance of caution, I'm going to go ahead and grant the motion just to make sure that there isn't anything out there. It sounds like there hasn't been a great deal of diligence from this company in providing information. So I want to make sure that the plaintiffs get what they need. So I'm going to grant the motion to compel. Let's go ahead and move to the motion for summary judgment.
Thank you, Your Honor. We filed a no evidence motion for summary judgment on defenses raised by the defendants. Initially, we filed it as both a summary judgment on the counterclaim that they had filed and also on the defenses. They then, around a month ago or so, withdrew the counterclaim and filed a new amended answer asserting, a slew of defenses, and we've moved for summary judgment on those. And
Go ahead.
It's all no evidence summary judgment at this point.
Okay, Mr. Harper.
Yes, Your Honor. I think a little bit of background on this case in the facts will help Your Honor understand that there is an abundance of evidence on each of the affirmative defenses. And I'm going to attempt to share my screen, if that's okay with Your Honor, so you can kind of have some visuals as to what we're talking about.
Okay. I don't know if that'll work, but okay.
Oh, it says host disabled attendee screen share. I will just talk through them.
Let me see if I can go ahead and do that, but I'm going to try to let you do that. Let's see. All right. I'm going to go ahead and try to do it again.
Yes, Your Honor.
Okay.
Can you see my screen now?
Yep.
Okay. This is the cover sheet for Exhibit D to a responsive motion. Exhibit D was Exhibit 4 to Mr. Jacob Johnson, the driver's deposition. This is the scene of the accident, Your Honor. The plaintiff's vehicle was proceeding north on South Buckner Avenue and merging into the service lane of I-30 going east. As you can see in this Google Maps photo, if you can see my cursor, this is Buckner Avenue, and going left to right is Interstate 30 frontage road. As plaintiff's vehicle went through to merge into traffic, the accident occurred. You'll see that, and I have some other demonstrative, and this, by the way, is marked up. The pencil or the pen was marked up by Defendant Johnson in his deposition. I have added the red. And so Defendant Johnson was trying to identify where the yield sign was in this case and where the plaintiff's vehicle was in this case when the accident occurred. After review, it really appears that the yield sign is where the red square is, because you can see the shadow in the document. So what happened was Miss Rebecca Solorzano, one of the plaintiffs in this case, she was driving her sister's vehicle, and she proceeded through the yield sign, got into the flow of traffic, and abruptly stopped her vehicle when a very minor accident occurred. Testimony reveals it's about a 5 to 8 mile an hour fender bender. Mr. Johnson testified through the exhibits and through his testimony that she was past the yield sign. Here's a photo, a Google Maps image showing the view from the service road. You can see there's a stop sign right before the merge area. And so there was immediate stops going into the service lane before the yield sign. Here's another photo marked up by defendant's counsel. This is a view, a Google Street view of coming from South Buckner onto the service road, which is going left to right. Defendant Johnson identified where the plaintiff's vehicle was, which was in the flow of traffic when the accident occurred. As you can see, Mr. Johnson testified, and I'm going to Exhibit A of the responsive brief, and these are excerpts from Mr. Johnson's deposition. And we're just talking about the yield sign here. It's like, and he was being questioned by plaintiff's counsel, Ms. Gonzalez, and she asked if there's a yield sign, and do you expect cars that are yielding to be stopped? And Johnson, he's like, I expect that cars are yielding to be stopped. I don't expect them to stop when they're past the stop sign. And how far, he couldn't tell, but are you 100% she was past the yield sign as you sit here? And he said, correct. He also testified that there was no other traffic in the service lane. He was questioned when merging onto the service road, Mr. Solorzano was already in the merge lane. Miss Solorzano was, and that's Miss Rebecca Solorzano was already in the merge lane. Yes. And he had testified to that earlier. He said there was no other traffic on the service road. As you go on to the page break, there's no other traffic on the service road in her lane that you recall. No, not in her lane. So she was yielding, or she was going past the yield sign into the service road. There was no traffic. And there's an indication of why there was no traffic. If you look at the Exhibit D, which is Exhibit 4 to Mr. Johnson's deposition, you see there are stop signs prior to, for any car that's about to enter into the service road. So it's not like it's a busy service road where there's a constant flow of traffic and there's cars everywhere. There's a stop sign prior to where the merge lane is. So it's an intermittent flow of traffic, not a constant flow of traffic here, Your Honor. And Mr. Johnson testified there was no traffic in the merge lane, in Ms. Rebecca Solorzano's merge lane. There are stop signs which would validate that. I actually drove this, Your Honor, and I went to the stop sign and I accelerated as fast as I could all the way to the merge lane. And it took me about 4 seconds. And I mean,
I object to this. This isn't evidence.
Okay. I'm just trying to give you your background, Your Honor. I'm not entering this into evidence. But there's, with the intermittent flow.
Harper, this isn't an opening statement. I mean, this is a summary judgment. So let's deal with the legal issues that we have here. One of the arguments you make is that you can't grant a summary judgment on an inferential rebuttal issue. So let's talk a little bit about that.
Yes, sir. Inferential rebuttal issue. And I'll bring up, where is that? Bed Bath & Beyond, Your Honor. Inferential rebuttal issue requires the plaintiffs to remove the non-existence of an affirmative defense, or in this case, seeks to disprove the existence of an essential element submitted in another issue. And so inferential rebuttal and the issues that raise an inferential rebuttal are the proportionate responsibility that we have raised in our answer, as well as the intervening cause. And if you look at another Texas Supreme Court case, Select Insurance Company, it's Select Insurance Company versus Buescher, and it talks about the inferential rebuttal and states that the inferential rebuttal issues have been variously referred to as the denial issues or argumentative denials. And the reasoning behind these labels are that they disprove by establishing the truth of a positive factual theory which is inconsistent with the existence of some factual element of the ground of recovery or defense relied upon by the opponent. Here, plaintiffs are saying that we're negligent, there is no contributory negligent. We have presented evidence, and we will at trial, that our factual theory and the evidence backs this up, and there's more than a scintilla of evidence. There's more than an issue of material fact, that we have a positive factual theory which is inconsistent with the existence of their factual element, which was we were negligent and were below the standard of care. The inferential, the proportionate responsibility, Your Honor. See if I can pull it up.
Your Honor,
Yeah.
the actual inferential rebuttal issues that they're talking about, I think we need to address whether summary judgment can be granted on inferential rebuttal issue. And I haven't heard.
That's what I was asking about.
Yeah.
Yeah, inferential rebuttal issues, Your Honor, go to, in my understanding, as to the, whether a jury instruction can be given on those inferential rebuttals. That is for Your Honor to decide based on the evidence presented at trial, not based on evidence prior to trial, Your Honor. And the proportionate responsibility in intervening causes, are these things that were presented at trial. And if Your Honor decides at that time there isn't any evidence to submit the jury instruction, that's the appropriate time to decide that, not a motion for summary judgment.
What case law do you have that indicates that a judge is not allowed to grant a summary judgment on an inferential rebuttal issue? I mean, you've cited that if you raise a fact issue, you shouldn't grant it. If you don't raise a fact issue or a genuine issue of material fact, then why couldn't you grant a summary judgment on an inferential rebuttal issue?
Well, I believe, Your Honor, that goes to the jury instructions, and the jury instructions, you will decide before it's presented to the jury after the close of evidence in this trial whether an inferential rebuttal has been presented. I do believe here, however, whether or not the issue is present for and available as for motions for available for summary judgment here, we have presented facts, and we do have facts which support those inferential rebuttals, which I can go through, Your Honor, if you would like.
Well, there's two issues here. One is your initial position was no matter what, for some reason, I'm not exactly clear. I've never heard anyone make this argument that a judge is not ever allowed to grant a summary judgment involving an inferential rebuttal issue. I don't know that that is the law, and I don't see that anything that you've cited indicates that's the law. The second issue would be, well, if I can, have you raised the genuine issue of material fact, and then that's a separate issue. And so what case law is there that indicates that you can't, a court is not allowed to grant summary judgment on an inferential rebuttal issue on that point exactly?
I don't have anything on that point exactly, Your Honor. I was using Bed Bath & Beyond and Select Insurance, Your Honor, relating to these inferential rebuttals, which relate to the jury instructions, and it being a jury instruction on, the proportionate responsibility. And it goes to actually the Civil Practice and Remedies Code on proportionate responsibility, which states that, if I can actually find it on my screen, that it's the proportionate responsibility, it shall be decided by the trier of fact. And I think I may have closed. Oh, here it is. Pardon me, Your Honor, I'm having technical difficulties. Here it is, Civil Practice and Remedies Code, determination of percentage of responsibility on which an inferential rebuttal is appropriate. It says the trier of fact as to each cause of action asserted shall determine, and here's to the contributing to cause in any way the harm of which recovery of damages is sought. So to the extent it's proportional responsibility.
In a summary judgment, isn't the judge the trier of fact?
For summary judgment, it is, Your Honor, and I understand and I appreciate your point, but there are facts here that rise above a mere scintilla of evidence that would present it to the jury, and it is for the jury to decide, Your Honor. There is not an absence of evidence that would support, Your Honor, of trier of fact in this issue. And so I do believe it is something that summary judgment should not be ruled upon in this case.
All right. Briefly, just kind of discuss what the fact issues that you think you've raised are.
Okay. There are several affirmative defenses that they moved on with respect to affirmative defenses. One is contributory negligence, Your Honor, and I went through in my background of the case regarding, plaintiff Rebecca Solorzano moving into the lane of traffic before she stopped. We believe there's a fact issue as to whether she was negligent and whether she was improperly impeding the flow of traffic by doing so. We have evidence from Mr. Johnson stating that she was, and his markup at the exhibits in Exhibit 4 showing that. As far as the pre-existing and subsequent conditions, we have evidence that Rebecca Solorzano had been in 2 wrecks prior to this in the last couple of years, one of which required her to go to the emergency room, complaining of stiffness and soreness in her neck and back, which are the same medical issues she is complaining of here. She is also testified that she works in an environment that requires her to lift heavily. These could also be conditions which exacerbated her injuries from her prior wreck. As far as negligent entrustment, Your Honor, negligent entrustment, as you know, the elements are that, the facts in this case are Jacqueline Jaime Solorzano, who's one of the plaintiffs in this case. She was the owner of the vehicle, and because she was pregnant, she testified that on many times, and because of the pregnancy, she entrusted her vehicle to her sister to drive. Both Miss Rebecca Solorzano and Jacqueline Solorzano are unlicensed drivers. Rebecca received a citation for being unlicensed. She moved here, has never sought a license, never had a United States valid driver's license. And at the time of the entrustment, her sister knew, or at least she should have known, that her sister didn't have a driver's license. Like I said, neither of them had licenses.
Right. Get to the next issue, please.
Okay, the next issue.
Objection. I don't believe there's any evidence at all that she knew that Rebecca did not have a driver's license. If he could point to that, I'd appreciate it. That would just address that right down.
Yes, it's not that she had actual knowledge, it's that she knew or she should have known. They were sisters.
That's what I was asking, because I wasn't aware of anything about that.
Okay, they were sisters. They lived together. They moved from Mexico together. They lived, getting a valid driver's license and a valid United States ID would be a big deal within that family. She knew or should have known that she did not have a driver's license. We believe the facts and the closeness of the sisters and knowing that neither of them had a driver's license, I believe one would know that the other did not or should have known. We believe Ms. Solorzano was negligent. Rebecca was negligent on the occasion for the reasons we outlined above. And that was the proximate cause of the injuries, or at least a contributing proximate cause to the injuries. And so this negligent entrustment to someone that Jacqueline knew or should have known did not have a driver's license, was reckless or incompetent in driving, having not gone through any driver training in the United States, is the factual basis for the negligent entrustment. And as far as failures to mitigate damages, Your Honor, that's another affirmative defense. Plaintiffs in this case had the accident. They waited over 2 weeks, and in fact, to seek medical treatment on this issue. They worked during that time, in which they both testified that they lift heavy objects during their work and did not seek medical treatment until they met with plaintiff's attorneys. And they met with plaintiff's attorneys and then immediately went to see the chiropractor, in which they claimed medical damages.
No evidence of any of this. In fact, he didn't even address failure to mitigate in his response.
The next, Your Honor, is proportionate responsibility, Chapter 33, like we...
Did you, Mr. Harper, did you address that in your response?
I believe, I thought we mentioned it, Your Honor. If we didn't, that was an oversight, but I do understand if it's not the response, then it's not, not at issue. So,
Okay.
proportionate responsibility under Chapter 33, we testified to that earlier,
Right.
where we talked about that earlier. We talked about Rebecca's negligence. Not only was it respect to the pulling into the merge lane of traffic, but also one of the other plaintiffs, Oscar Bautista, he was at the time of the accident was under the age of 8. He was 7 years old. Rebecca was cited for not properly restraining him in a child safety seat. She was cited for that, cited for not having a driver's license. This fell below the standard of care and was the proximate cause of the injuries to all the plaintiffs, and the proximate cause to the injuries of Mr. Oscar Bautista was his not being properly restrained in the child safety seat. And then as far as the negligence with respect to Jacqueline, we just listed this separately, and this goes to the negligent entrustment of her vehicle that she owned to her sister that she knew or should have known did not have a driver's license. So those are the issues, Your Honor, and those are the factual bases for our affirmative defenses.
Response?
Um,
And I really want you to just focus on the negligent entrustment and the negligence for not using a child seat.
Okay. I'll take the child seat on first. First of all, that's not contributory negligence because the only allegation is that one plaintiff is responsible for causing the injury to another, not that the plaintiff caused the injury to himself, the minor. The minor didn't cause the injury to himself. And not having, I don't see how not belting someone into a child seat caused injury to the other plaintiffs, but that's what he's arguing today. It simply doesn't make sense. It's not evidence of contributory negligence. And the overarching thing with all of these is there's absolutely no evidence of causation. There's been no citation to any evidence of causation. They've only stated that, well, this was the cause. This was the proximate cause. They haven't identified any evidence showing proximate cause. This is especially relevant in the negligent entrustment area because they haven't shown any evidence of causation that entrusting a vehicle to, that Jacqueline entrusting the vehicle to Rebecca proximately caused the collision in this case. It's just simply not there. They also haven't shown any proximate causation as to how Rebecca could have possibly caused the defendant to slam into the back of her car. There's no dispute that Rebecca and the vehicle was stopped at the time of the collision.
So let me ask you this. There's a number of cases that have occurred for years and years and years. Defendants weren't allowed to bring up, or neither party was allowed to bring up, the use of seat belts. I know this is slightly different because it's a child safety restraint, but it's the same concept. Have you, how does that play into, now it can be brought up in certain circumstances, how does that case law play into this case?
Well, I would say, Your Honor, it's the issue isn't even relevant because it doesn't matter. That it is not evidence of contributory negligence. Now, if they had, there's perhaps other ways they might have argued this, but here we're talking about contributory negligence. Whether Oscar Bautista contributed to his injuries when he was 7 years old by not being belted into the car seat. That just simply, there isn't any evidence of that. They don't even argue that. They argue that by not belting in the child to the car seat, that they contributed and caused the collision and the injuries to all the plaintiffs. And that just doesn't make sense. And that's what I just heard. And so I don't see any, for one thing, the most important part here is, where's the causation evidence? There simply isn't any.
So let me tell you my thoughts on this. I'm not going to rule on this now. Your trial settings, I don't think until December. Is that right?
I think it's June, actually.
Oh, okay. I thought it was December. Is that
That, but I think it's June.
Mr. Harper? Is that right, or when is it?
The latest I've seen was June 17th or something like that, Your Honor, which,
Okay.
yeah.
It's extremely likely that's going to get reset. I disagree. I think that the case law on seatbelt use is pretty relevant to the issues in this case. And so I'd like each of you guys to do a short letter brief looking at some of the recent Supreme Court cases on that issue. I know that it's kind of nuanced on how they've dealt with this and how does that play into what we're doing now. I'm going to try to rule on this before trial, but probably not much before trial. So give me a letter brief. Go ahead and email it to my court coordinator, and as well as e-filing it. Try to get that to me by, let's say, next Friday. But I don't want you to cover. It needs to be less than 2 pages and just cover the issues involving the seatbelt. All right, guys. Anything else?
Your Honor, unless you want argument on the other affirmative defenses, or if you want to hear anything regarding infringement rebuttal, then I don't have anything else.
Right. Mr. Harper?
Nothing, Your Honor. Unless you wanted to hear something, I think plaintiff's counsel misunderstood, regarding causation, because I think we put in, quite a bit of evidence on causation.
Okay, great. Thank you, guys. We're going to go ahead and turn off the recording, and we'll get you a ruling by prior to trial.
Thank you, Your Honor.
Thank you, Your Honor.
Bye-bye.